Residential listing agreement. You're looking for the residential listing agreement exclusive in case anybody was wondering. There's a couple of different options, your open option and seller reserve. So just so you know, there's a couple different options. Just avoid those altogether and go with the exclusive. But how it would go if you had a non-exclusive residential listing agreement is you would only get credit if you were actually the person that helped procure the buyer. So through your marketing or your open house or whatever, there was a buyer that came through, that's how you would get paid. If the seller secured their own buyer, you would not get paid. So that's why we like the exclusive, is it allows you to get paid no matter how the buyer is located and found. Okay. If they sell their house, you get paid with the exclusive. So we always go exclusive, residential listing agreement exclusive. That's why we also talked about too on when we covered the buyer representation and broker compensation agreement, the BRBC, that we always go check that little exclusive box as well, so that we get credit as long as that agency relationship is in place. Okay, so the residential listing agreement has documents that are included with it. Do not delete them, do not eliminate them. They must be included with it because there's boxes checked inside the listing agreement that say these are included. One of them is that disclosure regarding real estate agency relationship. Again, this form just tells somebody how they can be represented in a real estate transaction. Somebody can be represented with a seller's agent. Somebody can be represented with a buyer's agent, or you might be representing both the buyer and the seller in a transaction. And then it talks about the buyer and seller responsibilities with regards to those transactions. So this is our agency disclosure document. It goes out with all of our purchase agreements, our representation agreements, our listing agreements. It goes out and gets signed so that people understand the ways that they can be represented. In this document, you want to make sure to check those seller boxes, fill in the seller name, fill in your information, broker license, your name, your license number, super simple. Second page of this document is just all the legal jargon. No, I've never read the second page. Yes, I've read all of these forms and I have not ever read the actual second page of the civil codes for the agency disclosure. The Fair Housing Discrimination Advisory just explains to our potential customers that we cannot discriminate based on, Anastasia, I'm going to mute you just because you have a lot of background noise going on.
I'm sorry, I forgot. Husband's vacuuming.
It's all right. You can vacuum. We'll let you vacuum. I just don't want to hear it.
No, my husband's vacuuming.
Oh, he's vacuuming. Well, he can vacuum. I just don't want to hear it. It's very distracting. All right. Fair Housing and Discrimination Advisory just explains that we cannot discriminate as a real estate professional on the basis of any of the protected classes. And here's the little block that identifies all of the protected classes, which we may not discriminate upon. And it just talks about that we prohibit that, who's required to comply, right? Discriminatory effect, examples of what that might look like, examples of positive practices. So if you want to know what a positive non-discrimination act looks like, right here, section 10A through E gives you some examples. Your fair housing resources, in case you ever feel like you are discriminated against, here's where you can go to file a complaint. Limited exceptions to fair housing requirements. It just talks about who's exempt, right? Like a legally compliant senior housing community is exempt from, age discrimination. They can require that you are 55 or older to live in that property. Okay, super easy. It also talks about rental purposes. Owner of a single family residence who resides at the property with one lodger may be exempt, right? So if you're renting out a room in your house, then you could be exempt as well. You could discriminate, right? Because maybe you only want female roommates. Totally appropriate. Owner of a single family residence may be exempt from the FHA for sale or rental purposes, provide no license state, right? So it lists all the reasons. We are licensed real estate professionals. We're not exempt. So have your buyer or seller sign that. It would be a seller in this case. You would put it in here. Your possible representation of more than one buyer or seller, disclosure and consent just says that, hey, we may be representing more than one buyer or seller at the same time that we are representing you. We do not steer buyers away from our listings. We do not, pigeonhole people into our listings. We market them all equally and to the masses. Okay. Talks about multiple buyers, multiple sellers, dual agency if we're representing both buyers and sellers. And that the fact that the offers aren't necessarily confidential, right? So this applies for our buyers when we are signing that buyer or purchase agreement. You're right. We let our buyers know that, hey, your offers aren't confidential, that the seller may disclose information to other potential agents or potential buyers to try to get a better offer. Totally okay to do that. Here's where it says again, right, for the seller, right, we're letting the seller know that, hey, we can share that information. The buyer's been made aware so that we can work to get you the best offer possible for your property. Okay. Super simple there. Your wire fraud and electronic funds transfer advisory, always please make sure you don't transfer funds without verifying with the receiver that the instructions are accurate and correct, because there is wire fraud. And then we finally, on page 7 out of 14, halfway through this document, we finally reach what we call the residential listing agreement. Okay. This is a fabulous document. This is what we sign when we're going to secure a listing. You double click, it'll put in your date prepared. You're going to put in the seller's names here. Seller 1, seller 2, right? Make sure it's their legal name. We like to double check what's on the tax and title records to ensure that we're trying to make sure that if the seller's name on the tax records shows that they have a middle initial, please put that middle initial in here. We want it to match as accurately as possible what is on those tax records. Here in the broker, that's where you're going to put in your brokerage information, right? The broker's name. And in order for this listing agreement to be valid, it has to have a start date and a termination date. Otherwise, it's an invalid listing agreement. So you can put in today's date, right? If you're going to go to that listing appointment right now, this afternoon or whatever, you could just double click on it, puts in today's date. Let's say your appointment's tomorrow. We can predate it for tomorrow. And then we put an expiration date. The expiration date's totally up to you. You can be like, I have mine expire every 3 months, or I expire every 6 months. So we'd be like February 15th. And then we were like, March, I don't know my months of the year, March, April, May, June, July, August, right? It might be like, hey, August 15th is our expiration date. Or some agents have all of their listing agreements expire on either June 30th or December 30th, right? So that there's 2 times a year that they have to worry about their listings expiring. They're not random dates throughout the calendar. So you can decide how you do it. I highly recommend that however you end up doing that, you probably either have them expire on like the 1st of the month or the 30th of the month, only because it makes it easier to track for you. But make sure you put it on your calendar, that listing expiration date, once your listing agreement's signed. And make sure you put that your first reminder that that listing is about to expire comes up like a week before, so you can have conversations with your sellers if it hasn't sold yet. Number 1, how to get it sold. And number 2, if you need to extend that listing agreement. An exclusive and irrevocable right to sell or exchange the real property described as, here's where you're going to put in your address. We want the address, again, to match the tax records, make sure it's accurate. And please make sure to put in that street, drive, lane, court, plaza, I don't know what else there are, circle, right? Whatever it is at the end. So it's not just 1, 2, 3 test. We want it to be 1, 2, 3 test street or test drive or test court, because oftentimes there's duplicate addresses if we don't include that little thing at the end. Make sure you put the county in there, make sure you put the zip code in there, and then also make sure you put the parcel number in here. There's a couple different ways you can find that parcel number. One is the tax records, easiest way, right? It's in the tax records. You probably needed it to look up the tax records, or you can go into the MLS. If this property has been listed previously, plug in the listing information, right? The address, hit search, it'll pull up all the old listings for this property. You can pull the parcel number right off that old listing. Okay. If it's a manufactured mobile home, you're going to click this box here and you're going to include the MHLA, which would be your manufactured home or mobile home listing addendum. Okay, even if it's a real property mobile home on a permanent foundation, we still need to include that addendum if it's a manufactured mobile home type situation. Or if this property is being sold as a probate, conservatorship, guardianship, or receivership, you're going to see for the probate listing addendum and advisory, CAR form PLA for additional terms. So you check this box here, right? So you got those two
Amy?
options. Yes.
Do we have to do a special class to sell properties under that stature?
No.
Okay,
You do not.
thank you. Because I see them post classes all the time for probate and stuff. So I was just wondering if you had to go through that class in order to sell a probate property or a trust.
You do
property.
not, but you can get that probate designation, which could help you if those are the properties that you're targeting.
Okay.
It
thank
also
you.
is a good class to take because there's a lot of little nuances to probate. So it's a good class at some point to attend and take so that you understand the process.
Hey, Amy,
Thank you very much.
Yep.
for
yeah,
your,
absolutely.
when you said you put in the person's name,
Yes.
wherever that was, oh, seller one
Here
and
at the
seller
top.
two. Yeah, so if you're doing, if you're doing, like I just asked, is there another thing you should check for, like when you have somebody signing as the attorney in fact, like to check? Cause I just kind of said, how do you sign? Like, and I just put her first and like a first and last name. Is there something that could cause an issue later that I should check
Yes.
now?
So the seller's name should always be whatever's listed on
Oh,
title.
that's right. That's right. We did that.
Okay.
That's right.
And
Never
then
mind.
when we get to the
Yeah.
signature lines
That's-
at the end, you'll see that there's a box, and then that's where you would have like Heather Garcia signing as attorney in fact for on behalf
Yeah.
of, or whatever,
Yeah.
and then the seller's name.
That's right.
Yep.
That's right. Okay. I was like, wait, I don't remember doing that.
That was a good question though, right? If you're representing a purchase that, or a listing that has a LLC, or it's a trust or a probate or whatever, there's a trustee or an attorney, in fact, in charge of it or whatnot. Great question there. You would put the name of the legal owner of the property on the seller line, and then who signs on behalf of them is a different conversation. Okay, so legal seller goes here. Section 2 is your listing price and terms. Here's where you're going to put in the listing price shall be. Now, keep in mind that if we pre-printed all of this information at the top and we've pre-printed most of this, if we take this listing agreement to our listing appointment, and then we're going to have them sign in person, and we're also going to write in the sales price in person, please have them initial that they acknowledge that it was written in, just so we have their acknowledgement on that all of this was printed out, and then we wrote in the price. They acknowledged that they saw the price when we wrote it in, not that this was blank. They signed everything and then we went back to the office and filled it in, right? They need to sign to acknowledge the price. So you're going to put that in here. So let's say it was 500,000. There you go. You type it in down there. It fills it in for you up here. And then on listing terms, this is where you could add a clause, right? So this is where, hey, if you've got clauses saved under your templates, this is where you could pull those clauses in. So let's say on listing terms, I always put in here that if on market date is, I can't type today, more than 2 weeks after RLA is signed, listing price will be I don't look like that terminology. I don't know what I normally put looked at prior at 1 week. Let's go 10 days. 10 days prior to on market date. Right. And then I could save that as a clause. And then every time I pull up that listing agreement, I can just go into clauses and throw that in here if it's going to be more than 2 weeks. Or I could set it up in my template too, just so you know. You could always set it up as a template, but you can save those as clauses under your templates. It's got templates for the forms and then templates for clauses. So you can save those things that you normally type in under this with this new editing program. So super fancy there. Compensation to brokers, right? Okay, so here's the thing, right? This isn't valid without that start date and an end date. It's also not valid without a listing price. So if you're like, we're not going on the market for 3 months, we don't want to decide on a listing price. Sorry, you have to. Like, you actually have to. So you have to fill something in here for this to be an accurate listing agreement. So look at what the current market looks like and use a conservative number to fill in there. And you can let them know, like, hey, we're just using a conservative number here. The market is This is where I would put it on if we were going on the market today, or this is, today's market minus just a little bit, just to have a little cushion there. But hey, once we get within 10 days of our on market date, we're going to re-pull comps and re-look at that and have a conversation about where it's actually going to be listed when we come on the market. Is that fair? And they're going to be like, oh yeah, that totally makes sense, because the market's moving and changing. So we need to explain that to them.
Hey,
Here
Amy,
on yeah.
oh, I'm sorry.
Yeah.
We have to put the assessor's number, right? From the.
You do need a parcel number.
Okay. Okay.
There you go. Is that better?
Okay, there you go.
There you go. Yes, you do need a parcel number. Everything needs to be filled out completely on this form. Your compensation because, okay, here's the deal, right? This assessor's parcel number, that's actually the legal description of the property. The address is just how we know it. That's your common description. So this is actually more important than the actual street address itself, but you do need to have both of them in place. All right. Compensation to broker is section 3. The amount and rate of real estate commissions is not fixed by law. They are set by each broker individually, may be negotiable between seller and broker. Real estate commissions include all compensation and fees to broker. Seller agrees to pay broker compensation for services, irrespective of agency relationships, either blank % of the listing price, or if a purchase agreement is entered into of the listing price, or if purchase agreement is entered into the purchase price, or blank. So your option is either a % or a flat rate. Those are your two options. You're going to select one and fill it in. Please don't forget to check the box. Okay, so we're going to put in a % there. Your other option is you can choose a % or a flat rate, and you could fill in something else, right? So you could fill in, if you had like an additional fee to cover your back office expenses of $600, or, whatever it might be, you could fill that in there. Okay. And then it goes through and describes, right, if during the listing period or any extension, broker, cooperating broker, seller, or any other person procures a ready, willing, and able buyer who is offered to purchase the property at any price and terms is accepted by seller, provided the buyer completes the transaction or is prevented from doing so by the seller, broker is entitled to compensation, whether any resulting escrow from such offer closes during for the expiration of the listing period or any extension. So what that means is, hey, we have located a buyer who is ready, willing, and able. They've put an offer in. Oh my gosh, middle transaction, seller has a conniption fit and cancels the listing. You're still due a commission because that was canceled by the seller. Now, if the buyer has the conniption fit and cancels, you are not due a commission because it was the buyer who prevented the sale, not the seller who prevented the sale. You're going to have to go find a new buyer. Okay, so that's what that means there. And at the end where it talks about the during or after the expiration period of this listing, if we are in contract to sell this house with a buyer and this expiration date of this listing agreement comes into play, the agreement continues on until the completion of that transaction because you're already in contract. So that's what it means there. Okay. So that would be one way in which you're due compensation. The second is if within blank calendar days after the end of the listing period or any extension or after any cancellation of this agreement, unless otherwise agreed, seller enters into a contract to sell, convey, lease, or otherwise transfer the property to anyone, prospective buyer, or that person's related entity who physically entered and was shown the property during the listing period or any extension by the broker or cooperating broker, or for whom the broker or any cooperating broker submitted to seller a signed written offer to acquire, lease, exchange, or obtain an option on the property. Seller, however, shall have no obligation to broker under paragraph 3A2 unless no later than the end of the listing period or any extension or cancellation, broker has given seller a written notice of the names of such prospective buyers. Okay, this is not filled in. Okay, if you do not fill this line in here, this whole paragraph really truly is invalid. Okay, so if within, right, 90 days, 30 days, 60 days, 120 days, whatever you want to put in here. If within 120 calendar days after the end of the listing period or any extension, right, or after any cancellation of this agreement, right? So it has both of those clauses, either the end of the listing period or an extension, or after the cancellation of this agreement, unless otherwise agreed to. And then it lists, what forms happen here that would cause you to get paid a commission. This protects you so that the seller can't cancel the listing agreement or delay accepting an offer. And then after the listing expires, they turn back around and they reach out to one of those buyers who wrote an offer during that listing period. This is to protect you so that we don't sandbag selling the house so that they don't have to pay a commission. Okay, so make sure you put that in there. You also need to provide them with a list of who saw the property. So it might be in your best interest when somebody asks to see the property for you to ask for their buyers' names when you set up those showings and let them know that you're not going to try to contact them. You just want to make sure they're protected by their client relationship. You can even say, hey, I've had instances where I've had buyers see it with one agent and then write an offer with another agent. I just want to know who showed them the property so that if that ever happened, I could go back to you and let you know that your buyers wrote an offer with another agent, right? Like full disclosure, I'm not trying to contact your buyers. I'm just protecting my seller and I'm protecting you. Right? Super simple. 3, so that's the second way that you could receive compensation. Or the third way is without broker's prior consent, the property is withdrawn from sale, conveyed, leased, rented, or otherwise transferred or made unmarketable by a voluntary act of the seller during the listing period or any extension. Right? So if the seller we have a listing agreement in place, seller turns around and decides, hey, I decided to rent it. I found renters for the property, right? You could be like, actually, I'm due a commission because the property is no longer available for sale. And this is part of our listing agreement. Okay. Whether you decide to hold somebody's feet to the fire in that situation is up to you. And in most cases, your seller probably should have had a conversation with you before looking for renters to let you know that, hey, we're thinking about taking it off the market. You can continue to market it for sale. But if I find a renter before you find a buyer, then I'd like to pull it off the market. And you're gonna be like, yeah, that makes sense. Totally fine, right? So have that conversation. Hopefully you've got open dialogue with your sellers to be able to do that, but that would be another instance in which you might be due that commission, okay? So that's A. B is if completion of the sale is prevented by a party to the transaction other than the seller, then compensation which otherwise would have been earned under paragraph 3A shall be payable only if and when seller collects damage by suit, arbitration, settlement, or otherwise, and in an amount equal or lesser to 1/2 of the damages recovered, or the above compensation after first deducting title and escrow expenses and expenses of collection, if any. Right? So if the buyers prevent the close of the transaction, they have a freak out, they're like, no, I'm not going to buy it. And then the seller goes after them legally for damages, you would be due 1/2 of those damages up to and not to exceed the total commission negotiated minus any fees and costs for title, escrow, and collection. Okay. So that would be B. C is, in addition, seller agrees to pay broker. So if there's something you want to fill in there, please do. That would be C. That might be where you would put in like a cancellation clause in there, right? Pay broker, seller agrees to pay broker $1,000 if seller cancels listing prior to end of listing agreement.
Is that
Right?
where you would put in if we did the pictures and the inspections and they decided, no, they don't want to sell it, then they give us back that money that we put out for that stuff?
No, I usually put that down in that section because it says the seller is going to pay for those items in that section. And so I usually clarify that, hey, the agent will cover the cost of these items unless the property doesn't sell for any reason. So it's usually a little different thing.
Okay, copy. Thank you.
Okay, so there's lots of things you could put in addition, seller agrees to pay broker, but that would be, if you were going to charge a cancellation fee, that would be one place to put it in. That would be the best place to put it in. Let's put it that way. All right, seller has been advised of broker's policy regarding cooperation with and the amount of compensation offered to other brokers. Broker is authorized to cooperate and compensate brokers participating through the MLS service by offering MLS brokers out of broker's compensation specified in paragraph 3A, either blank % of the purchase price or blank dollars. So right here, again, we have that choice between % or flat fee. This is where you would fill in what you're going to offer to a buyer's agent who secures a buyer and brings you a buyer for the property. Okay, right there. And the only question I usually get regarding compensation is it this plus this? And you're like, no, it's this minus this. We're not adding them together. We're subtracting. They're like, oh, okay, that makes sense. Okay, that's usually the question I get. Okay, broker is authorized to cooperate and compensate brokers operating outside the MLS as per broker's policy. So keep in mind too that this only obligates us if it's a cooperating broker that's a member of our MLS service. So if a broker from or an agent from San Diego writes an offer on your property and they do not belong to the Barry's MLS system or a cooperating MLS system like MetroList or whatnot, then they're technically not due a commission unless they submit the form for cooperating broker compensation, at which point they should submit that with the offer to verify that they're getting the commission as offered to in the MLS. Okay, so anytime you're offering on a property, let you back in. What do you mean let you back in? Hold on, Heather's having technical difficulties.
She says she has to jump off her computer and get on her phone because she has to take her son to the
Oh,
collision police.
she's not asking to come back in yet. We'll let you back in when you're back, Heather. All right, sorry. So if you're offering on a property outside of our regular MLSs, you also should include that CBC form, that cooperating broker compensation form, to ensure that you're going to get paid for your work. Okay.
So when we see on the MLS, it says out of area, that's the one that we need to submit that additional form.
Anytime they've listed a property in the MLS, that should they've become a member of the MLS in order to list it in the MLS. It would be a property not listed in the MLS. Or if like you had a relative down in Fresno who's like, hey, Anastasia, can you please, I've got a property I want to buy. I've already seen it. I went through the open house. I know I want to buy it. You don't have to do, I just need you to handle the paperwork for me and, make sure I'm on par. I can get in to see it or whatever. And you're like, sure, I'll write the offer for you, right? You need to include that CBC form to make sure you get compensated for the offer because we're not part of that Fresno MLS.
Okay, gotcha. Thank you.
Yep. All right. E is seller hereby irrevocably assigns to broker the above compensation from the seller's funds and proceeds in escrow, right? That gives permission for escrow to take them out of the seller's funds. Broker may submit this agreement as instructions to compensate broker pursuant to paragraph 3A to any escrow regarding the property involving seller and a buyer, prospective buyer, or other transferee. This also would prove as proof if your seller went behind your back and entered into contract. You could give this as proof to the escrow company that you still have an agreement in place and you're due the commission. Seller represents that the seller has not previously entered into a listing agreement with another broker regarding the property unless specified as follows. So if they expired or canceled one to list with you, then you would list that previous listing agreement here with that whoever it was listed with. The seller warrants that seller has no obligation to pay compensation to any other brokerage regarding the property unless unless the property is transferred to any of the following individuals or entities. You could say see attached list. So if they canceled their listing agreement, their previous listing agent had provided them a list of people who had seen the property during the time specified in section A2. You had that list, you could say see attached list. Okay, or maybe you reached an agreement like, hey, I'm due a commission unless the neighbor buys it. Or unless your sister buys it, right? So they might say, hey, but my sister was thinking, like, I'd like to list the property, like to get the ball rolling on that. However, my sister's trying to get pre-approved to see if she can purchase it. So if she buys it, I don't want to be due a commission because it's my sister. Or I don't want to have to pay you a commission because it's my sister and we'll handle it without, I don't need you to do forms or anything. Then you could put in their name there. So if there's somebody there, you could enter that in or a list provided by another broker.
So that's why it's important for you to get people to sign in to your open houses.
This is why it's important to get people to sign into your open houses.
Yeah.
If the property is sold to anyone listed above during the time the seller is obligated to compensate another broker, broker is not entitled to compensation under this agreement, and the broker is not obligated to represent the seller in such transactions. So if there's somebody that they list here due to another agreement, due to side agreement that they have with you, whatever that is, we're not obligated to represent them if any of those situations arise. Okay, because we're not going to be compensated. We don't work for free. Nobody works for free. That's section 3. Section 4 is items excluded and included unless otherwise specified in the real estate purchase agreement. All fixtures and fittings that are attached to the property are included, and personal property items are excluded from the purchase price. Keep in mind that there's some gray area here. The new purchase contract did a much better job at explaining it, like it's the curtains and the rods all stay with the property. And it even goes to like shelves, right? Are the shelves like screwed to the wall, or are they hooked to the wall, right? If they're just like on little brackets and you can like lift them up and take them off, then it's decorative, versus one that's actually like bolted to the wall. That would be a fixture. So you really need to walk through the property with your seller and look at what's on their walls, look at what's in their house, what's in their garage. They have cabinets in that garage. Are they anchored to the wall or not, right? And we need to have conversations. If there's anything that's a gray area that could be construed as a fixture versus personal property, make a list of those items that aren't going to be included as part of the sale, so that we are above clear on everything when we enter into contract on the property. Okay, here are additional items included and additional items excluded. You can make a list here, or you could say see attached addendum. If you fill in more space than is allowed, it will go to automatically to a text overflow addendum, so you don't even have to add it. So you can either make an attached list if the seller put together a list, or you could just start typing in all the items here, and when it overflows, it'll automatically add a form for you. So it won't be cramped on this little line. Okay, seller intends that the above items to be excluded or included in offering the property for sale, but understands that the purchase agreement supersedes any intention expressed above and will ultimately determine which items are excluded and included in the sale. And broker is not responsible for and does not guarantee the above exclusions or inclusions will be with the purchase agreement. Okay, that's why we always want to have like a list, and we want to put it into our HomeLight listing management file, or it's in the MLS of items included or items excluded from the purchase. Okay, leased or not owned items. The following items are leased and not owned by the seller. What does the seller not own? Do they have payments on the solar power system, the alarm system, or propane tank, a water softener, or other, right? Liened items. Right, so that'd be leased, right? We don't own them, we make payments, but we don't actually own them. Liened items would be something that we're making payments on, but that we actually own. So the following items have been financed and a lien has been placed on the property to secure payment. Again, that solar power system, it could be leased or owned with payments. Windows and doors, heating, ventilation, and air conditioning system, or other. Okay, some people like finance their water filtration systems. Okay, seller will provide buyer as part of the sales agreement copy of lease documents and other documents obligating seller to pay such for any such leased or liened items. We need copies of those documents as early in advance as possible, so that the buyers know what they are getting into when they go to purchase those properties. So it's important that we get copies of all of those. Multiple listing service is section 5. What is an MLS? The MLS is a database of properties for sale that is available and disseminated to and accessible by all other real estate agents who are participants or subscribers to the MLS. As set forth in paragraph 7, participants and subscribers conducting public marketing of a property must submit the property information to the MLS. Property information submitted to the MLS describes the price, terms, and conditions under which the seller's property is offered for sale, including but not limited to the listing broker's offer of compensation to other brokers. It is highly likely that a significant number of real estate practitioners in any given area are participants or subscribers to the MLS. The MLS may also be part of a reciprocal agreement to which other MLS services belong. Real estate agents belonging to other MLS services that have reciprocal agreements with the MLS also have access to the information submitted to the MLS. The MLS may further transmit listing information to the internet sites that post property listings online. That would be places like Zillow and Realtor and Homes.com. What information is provided to the MLS? All of the terms of the transaction, including sales price and financing, if applicable, will be provided to the MLS in which the property is listed for publication, disseminated, and used by persons and entities on terms approved by the MLS, and may be provided to the MLS even if the property was not listed in the MLS. That would be like an off-market sale. We can still provide it to the MLS for comp purposes. It also helps with your numbers. If you're selling properties off market, we usually submit them as a off market sale to the MLS so that it's picked up in broker metrics and everything so that our numbers are accurate when people look up our information. Seller consents to the broker providing a copy of this listing agreement to the MLS if required by the MLS. What is broker's MLS? The broker is a participant subscriber to blank MLS service. For the most part, this is going to be Barry's. Okay. It could be MetroList. It could be, we actually belong to several different MLSs. So depending on where the property is listed, just find out what the primary one is. And you can ask the broker, are we a subscriber to that? And why is that important? Because this next sentence where it says that MLS is, or if checked, is not the primary MLS for the geographic area of the property. Okay, when required by paragraph 7 or by the MLS, property be listed with the MLS specified above, right? So we are members of Barry's. We are also members of MetroList. So if the property's in, Yolo, Sacramento, El Dorado counties, you could put in MetroList here so that you don't have to check this scary box that says it's not the primary MLS. Okay. So because it's asking about the broker, not the agent, right? So we may not be necessarily a subscriber, but our brokerage is. So it's better to put, if we belong to the primary MLS, put the primary MLS here so that we don't have to check that box. Okay. Super simple. Section 6 is the benefits of using the MLS or the impact of opting out of the MLS. Exposure to buyers through the MLS. Listing property with an MLS exposes a seller's property to all the real estate agents and brokers and their potential buyer clients who are participants or subscribers to the MLS or a reciprocating MLS. The MLS may further transmit the MLS database to internet sites that post property listings online. The impact of opting out of the MLS. If a seller elects to exclude property from the MLS, seller understands and acknowledges that the seller is authorizing limited exposure of the property and no marketing or advertising of the property to the public will occur. The real estate agents and brokers from other real estate offices and their buyer clients who have access to that MLS may not be aware of that seller's property is offered for sale. Information about the seller's property will not be transmitted from the MLS to various real estate internet sites that are used by the public to search for property listings, and real estate agents, brokers, and members of the public may be unaware of the terms and conditions under which the seller is marketing the property, right? Here's the impacts. Because keep in mind, if our MLS has a cooperating, clear cooperation policy, and that property is located in those, they fall underneath, you may not market that property off the MLS to the public in any way, shape, or form. You can only market that property to other agents inside your brokerage. That is it. No for sale sign, no coming soon signs, no mailers going out, no talking about it with other agents, no posting it on social media. So if it's not in the MLS, you cannot market that property for sale to the public. So that's the impact of opting out of the MLS. Yes, Anastasia?
Gotcha. Nope, I was just saying gotcha.
Fabulous. Reduction in exposure. Any reduction in exposure of the property may lower the number of offers and negatively impact the sales price. Not listing the property on a local MLS. If the property is listed in an MLS, which does not cover the geographic region where the property is located, then real estate agents and brokers working that territory and buyers they represent looking for property in the neighborhood may not be aware the property is for sale. Everybody initials that section, letting them know both the impacts of opting in or out of the MLS. The public marketing of the property is section 7, clear cooperation policy. The MLS rules require that a residential real property with 1 to 4 units and vacant lot listings be submitted to the MLS within 1 business day of any public marketing. Okay. Barry's, I believe, still doesn't fall within this. So you could check the box if it's a Barry's region, which would be Solano, Napa, Sonoma, Mendocino, and Marin counties. I believe Marin falls underneath Barry's. Then you could check the box for does not require. We can market those to the public, even if they're not on the MLS, meaning that we can market them for coming soon. Public marketing within clear cooperation. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing on public-facing websites, brokerage website displays, digital communication marketing, and email blasts, multi-brokerage listings, sharing networks, marketing or closed or private listing clubs or groups, and applications available to the general public. Public marketing does not include an office exclusive listing where there is direct promotion of the listing between the brokers and the licensees affiliated with the listing brokerage, and one-to-one promotion between these licensees and their clients, right? So I can market a property that I have not listed in the MLS with Anastasia, and Anastasia can market it to a potential client that she might have. Okay. But she may not
Got
post it online. Coming soon, status impact on marketing, days on market. Seller is advised to discuss with the broker the meaning of coming soon, as that term applies to the MLS in which the property will be listed, and how any coming soon status will impact when and how a listing will be viewable to the public via the MLS. Seller does authorize broker, right? So the default is seller does authorize. If we check the box, does not authorize broker to utilize coming soon status. If any, seller is further advised to discuss with broker how days on market calculations are similarly utilized tracking field works within the MLS for which the property is listed. Right, so that's the impact of coming soon. Either they authorize it or they don't authorize it. They can still authorize it even if you can't actually do it. The seller instructs broker. MLS may require Carform, SELM, or local equivalent. Seller instructs broker to market the property to the public and start marketing on the beginning date of this agreement or blank date. So it defaults to the date of this agreement. So if the date of this agreement is either going to be this date that we put in the top of page 1 or the date in which the seller signed it, whichever is last. Okay. So we're authorizing that coming soon listing over here based on that date. If the property is not going to go on the market right away, right? Or sorry, it's going to be like on market, not coming soon. If it's not going to go on the market right away, we're going to put this in here and put the date that we think it's going to go on the market. Okay, we can always change that date with a modification of terms form. Okay, seller so one is seller instructs broker to market the property to the public and start marketing it beginning on the date of this agreement. That's the default or blank date. The second option is seller instructs broker to not market the property to the public. Seller understands that no public marketing will occur, and the scope of marketing that will occur will consist of only direct one-on-one promotion between the brokers and licensee affiliated with the listing brokerage and their respective clients. So that's your second option there. Okay, you can either go do D1 or D2. Now, keep in mind, we can always change this. So if you're like, hey, we don't want to put it on the market yet, we're just going to mark that we're not ever putting it on the market, then we can always come back with a modification of terms and put seller instructs broker to market the property to the public beginning on blank date. So it really doesn't matter. Okay. Whether 7D1 or 7D2 is selected, seller understands and agree that should any public marketing of the property occur, the property listing will be submitted to the MLS within 1 business day, right? So that's where that, hey, we're supposed to submit it. So if we don't want to submit it to the MLS right away, then we would put here, that's where we'd use that SELM form, right? The SELM, SELM, the seller's exclusion from the multiple listing service, excluding it from being marketed. Clear cooperation policy does not apply. So if you're listing it in the Barry's service area, you can check this box for F. Paragraph 7A, other than language in parenthetical 7B, 7D, and 7E do not apply to this listing. Broker shall disclose to seller and obtain seller's consent for any instruction to not market the property on the MLS or to the public, right? So this, we can say, hey, it does not apply. We still want to do that SELM form though, just so you know, if we're not going to put it in the MLS right away with instructions on what our plans are with that. So you can put the clear cooperation policy does not apply. This allows us also to market it as a coming soon, even before it's in the MLS. MLS data on the internet. MLS rules allow MLS data to be made available by the MLS to additional internet sites unless broker gives the MLS instructions to the contrary. Specific information that can be excluded from the internet as permitted or in accordance with the MLS is as follows: property or property address, right? We can mark it so that the address doesn't pass through to the internet. Now, keep in mind, if we do that, it does not show up on any of the map searches. So it's not a good idea. Seller can instruct broker to have the MLS not display the property or the property address on the internet. Carform, SELI. Seller understands that either of these opt-outs would mean consumers searching for listings on the internet may not see the property or property's address in response to their search. feature opt-out, seller can instruct broker to advise the MLS that seller does not want visitors to MLS participant or subscriber websites or electronic displays that the property listing to have features below. We would also do this on CARM form SELI. Seller understands that these opt-outs may apply only to websites or electronic displays of MLS participants and subscribers who are real estate broker and agent members of the MLS, that other internet sites may or may not have features set forth herein, and that neither broker nor the MLS have the ability to control or block such features on other internet sites. Okay, you'd have to look at that form and see what's on there. Oh, here's the option. Comments and reviews. The ability to write comments or reviews about the property on those sites, or the ability to link another site containing such comments or reviews if the link is in immediate conjunction with the property display. Or the automated estimate of value, the ability to create an automated estimate of value or link to another site containing such estimate of value if the link is immediate conjunction with property display. Seller elects to opt out of certain internet features as provided by CAR form SELI or local equivalent form. So if they were going to opt out of any of these features, we would want to check that box and include that form. Okay. 9, seller representation. Seller represents that otherwise, unless otherwise specified in writing, seller is unaware of any notice of default recorded against the property, any delinquent amounts due under the loan secured by or obligation affecting the property, any bankruptcy, insolvency, or similar proceeding affecting the property, any litigation, arbitration, administrative action, government investigation, or other pending or threatened action that affects or may affect the property or seller's ability to transfer it, and any current pending proposed special assessments affecting the property. Seller shall promptly notify broker in writing if seller becomes aware of any of these items during the listing period or any extension thereof. Section 9 is the broker and seller's duties. The broker responsibility, authority, and limitations. Broker agrees to exercise reasonable effort and due diligence to achieve the purposes of this agreement. Unless seller gives broker written instructions to the contrary, broker is authorized but not required to order reports and disclosures, including those specified in 10E as necessary, advertise and market the property by any method in any medium selected by broker, including the MLS and the internet, and to the extent permitted by these media, control and the dissemination of the information submitted to any medium, and disclose to any real estate licensee making an inquiry of the receipt of any offers on the property and the offering price of such offers. We're given permission in the listing agreement to disclose the presence of additional offers and what the offer prices are. Okay. Presentation of offers. Broker agrees to present all offers received for the seller's property and present them to seller as soon as possible, unless seller gives broker written instructions to the contrary. So if the seller does not want to receive offers until a specific date, we need to have that in writing, either as part of our listing agreement or on a modification of terms. Buyer supplemental offer letters, buyer letters. Paragraph 8 of the Fair Housing and Discrimination Advisory attached to this listing agreement informs the seller of the practice of many buyers and their agents, including a buyer letter with an offer to try to influence the seller to accept the buyer's offer. Buyer letters may include photos and video. Whether overt or unintentional, buyer letters may contain information about a buyer's or seller's protected class or characteristics. Deciding whether to accept an offer based on upon protected classes or characteristics is unlawful. Broker will not review the content of the buyer letters. Seller instructs the broker to not present buyer letters, whether submitted with an offer or separately or at a different time. Seller authorizes the broker to specify in the MLS that buyer letters will not be presented to the seller. Right? That's the default. The default is we do not present letters, and you should have that verbiage in your listings. Buyer letters will not be presented to seller. Or B, seller instructs.
I've been seeing that a lot more.
Because you're supposed to include it.
Gotcha.
Seller instructs broker to present buyer letters would be the box B. Broker advises seller that buyer letters may contain information about protected classes or characteristics, and such information should not be used in the seller's decision of whether to accept, reject, or counter a buyer's offer. And if seller relies on buyer letters, seller is acting against broker's advice and should seek the advice of counsel before doing so. Right? So that would be, we're including those. Seller agrees to consider offers presented by broker and to act in good faith to accomplish the sale of the property by, among other things, making the property available for showing at reasonable times, and subject to paragraph 3F, referring to broker all inquiries of any party interested in the property. Seller is responsible for determining at what price to list and sell the properties. Seller's going to act in good faith to sell the property. That was D. E is investigation and reports. Seller agrees within 5 days of the beginning of this agreement, or you could put blank days, to order and, when required by the service provider, pay for the natural hazard disclosure report and the following reports. Look, it puts in there the seller is going to pay for that when required, right? We can check the boxes. So I ran up and down the stairs already, breathing. All right, structural pest control. We could check that box. General property inspection, that'd be like a whole home inspection. Homeowners association documents, preliminary title report, roof inspection, pool inspection, septic/sewer inspection, or other. Right, so you can check any of those boxes. You can check the box for other. We're gonna pre-open escrow. We're gonna have that NHD report, and we're gonna get a general property inspection. Probably a structural pest too. All right, you can choose how you want to do business. I highly recommend doing inspection reports ahead of time. If you read the Disclosure Information Advisory, the DIA form, it talks about the importance of pre-listing inspections. Number one, it eliminates any surprises. And number two, it helps the seller with disclosures. There's less chances that they're going to forget to disclose something if it's already in a report or an inspection. So it helps to protect the seller by doing those reports ahead of time. If the property is located in a common...
Sorry, can we just do a structural pest and a roof? Or what would you recommend, the general or the structural?
Well, so it's not a structure. I mean, it's called a structural pest control, but it's really looking for like dry rot, right? Or things damaging the wood of the property is why it's called structural. I would probably, in an area where there's a high military content, I would get that pest report done, that structural pest report done, with also including that Form 33 of the active infestation of actual bugs, so that you have both the full pest report and that Form 33, because most lenders will clear it off the Form 33. I would probably, if it were me, I would get a general property inspection over a roof inspection. Only because I feel like roof inspections are a little scarier to most people versus a general property inspection, which they also look at the roof, but they don't include like a quote with it. And they're also looking at the whole property. So if we're trying to eliminate potential risks or concerns with regards to the property, doing a whole house inspection is going to be a better overall general condition of the property and things that a buyer might find, right? They test all the systems and components and everything. So I would rather do a home inspection and a pest inspection than a roof inspection. And if I were only going to go for one, I would go for just the general property inspection. Again, it's that general overall health of the house.
Okay, thank you.
Yep. If it's a country property or it has a septic system, you may want to do a septic inspection, because generally speaking, it's polite for the sellers to pump their own poop. So usually have it inspected and pumped at the same time. Okay. We usually don't make for the buyers pay for the pumping of the seller's poop. Okay. If a property is located in a common interest development or homeowners association, sellers advise that there may be benefits to obtaining any required documents prior to entering into escrow with any buyer. Such benefits may include, but not limited to, potentially being able to lower costs in obtaining the documents and avoiding any potential delays or complications due to late or slow delivery of documents. They're consistently slow. Seller further agrees to indemnify, defend, and hold broker harmless for all claims, disputes, litigation, judgments, attorney fees, and costs arising from any incorrect or incomplete information supplied by the seller, or from any material facts the seller knows but fails to disclose, including dangerous or hidden conditions of the property. Okay, so those are the brokers and sellers' duties. Deposit. Broker is authorized to accept and hold on seller's behalf any deposits to be applied towards the purchase price. Keep in mind that we don't handle the buyer's money, those deposits. It all goes straight into escrow from the buyer. Please don't take the buyer's money. In other states, they actually, the listing brokerage holds those deposits. Okay, we don't do that here, but there are other states that do that. Disclosure. The seller acknowledges receipt of a disclosure regarding agency relationship, per Form AD. That was that first one we talked about. Seller representation. Broker shall represent seller in any resulting transaction except as specified in paragraph 3F. That was the one we already talked about. Possible dual agency with a buyer. Depending on the circumstances, it may be necessary or appropriate for a broker to act as an agent for both the seller and the buyer, exchange party, or one or more additional parties, buyer. Broker shall, as soon as practical, disclose to seller any election to act as a dual agent representing both the seller and the buyer. If a buyer is procured directly by the broker or an associate licensee in the broker's firm, seller hereby consents to the broker acting as a dual agent for the seller and buyer. In the event of an exchange, seller hereby consents to broker collecting compensation from additional parties for services rendered, provided there is a disclosure to all parties of such agency and compensation. Seller understands, we lost Heather again. Seller understands and agrees that a dual agent may not, without the express permission of a respective party, disclose to the other party confidential information, including but not limited to facts relating to either the buyer or seller's financial position, motivations, bargaining position, or other personal information that may impact the price, including the seller's willingness to accept a price less than the listing price or the buyer's willingness to pay a price greater than the price offered, and except as set forth above, a dual agent is obligated to disclose known facts materially affecting the property or desirability of the property to both parties. Confirmation, broker shall confirm agency relationship described above or is modified in writing prior to or concurrent with the seller's execution of the purchase agreement. Potentially competing sellers and buyers. Seller understands that broker may have or obtain listings on other properties and that potential buyers may consider make offers or purchase through broker property the same or similar to the seller's property. Seller consents to broker's representation of sellers and buyers of other properties before, during, and after the end of this agreement. Seller acknowledges the receipt of the possible representation of more than one seller or buyer, disclosure and consent. Termination of agency relationship. Seller acknowledges and agrees that representation duties of an agency relationship with broker terminate at the expiration of this agreement, or if it occurs first, the completion of any transaction specified in this agreement. Security, insurance, showings, audio, and visual. Broker is not responsible for loss or damage to personal or real property or person, whether attributable to the use of a key safe lockbox, a showing of the property, or otherwise third parties, including but not limited to appraisers, inspectors, brokers, and prospective buyers may have access to and take videos and photographs of the interior of the property. Seller agrees to take reasonable precautions to safeguard and protect valuables that might be accessible during showings of the property, to obtain insurance to protect against these risks. Broker does not maintain insurance to protect the seller. Persons visiting the property may not be aware that they could be recorded by audio or visual devices installed by the seller, such as nanny cams and hidden security cameras. Seller is advised to post a notice disclosing the existence of security devices. It is good practice, and I'm not in the habit of doing this, but it is good practice to post a sign at the door, or maybe even on the lockbox or wherever it might be as they walk in the door, that they may be recorded by audio or visual devices. Most homes have Ring cameras, most are Ring doorbells or Alexas or different things that may pick up their voice and record it. So it's always a good idea to include that with any of your potential listings. Photographs and internet advertising. In order to effectively market the property for sale, it is often necessary to provide photographs, virtual tours, and other media to buyers. Seller agrees that the broker may photograph or otherwise electronically capture images of the interior and exterior of the property, also known as images, right? So the default is agrees. If we check this box, they don't agree to photographs for static and or virtual tours of the property by buyers and others for use on the broker's website, the MLS, or other marketing materials and sites. Seller acknowledges that if broker engages third parties to capture and or reproduce and display images, the agreement between the broker and those third parties may provide such use of the images. If seller is concerned, seller should request that the broker provide any third party's agreement impacting the images. Seller also agrees that once the images are placed on the internet, neither the broker nor the seller has control over who can view such images and what viewers may make of the images, or how long such images may remain available on the internet. Seller further assigns any rights in all images to the broker agent and agrees that such images are the property of the broker agent, and that the broker agent may use such images for advertising, including post-sale and for broker agent's business in the future. Seller acknowledges that prospective buyers and other persons coming into the property may take photographs, videos, or other images of the property. Seller understands that broker does not have the ability to control or block the taking and use of images by such persons. If checked, the seller instructs the broker to publish in the MLS that taking of the images is limited to those persons preparing appraisal or inspection reports. Seller acknowledges that unauthorized, so it doesn't default to that. It defaults to anybody can take photos. Seller acknowledges that the unauthorized person may take images who do not have access to or read any limiting instructions in the MLS, or who take images regarding of any limiting instructions in the MLS. Once images are taken and are put into electronic display on the internet or otherwise, neither broker nor seller have control over who views such images or what those viewers may make of the images, right? Hey, we can tell people in the MLS not to take pictures, but we can't guarantee they're not going to, and we don't have control over what they do with those pictures if they went ahead and took them anyways. That's what that paragraph is saying. Key safe or lockbox. The key safe lockbox is designed to hold a key to the property to permit access to the property by broker, cooperating brokers, MLS participants, their authorized licensees and representatives, authorized inspectors, and accompanied prospective buyers. Seller further agrees that broker, at broker's discretion, without further approval from seller, shall have the right to grant access and convey seller's consent to access the property to inspectors, appraisers, workers, repair persons, and other persons requiring entry to the property in order to facilitate the sale of the property. Broker, cooperating brokers, MLS, and association boards of realtors are not insurers against injury, theft, loss, vandalism, or damage attributed to the use of the key safe lockbox. A seller does authorize broker to install a key safe lockbox is the default. If we check the box under 15A, it says does not authorize them to install a key safe lockbox. 15B is tenant occupied property. If a seller does not occupy the property, seller shall be responsible for obtaining occupants' written permission for use of a key safe lockbox. There's a form for that. It's called the KLA form. Make sure that they get it signed by the tenants of the property. 16 is a sign. The seller does authorize broker to install a for sale or sold sign on the property. If they check the box, they do not authorize that sign. Equal housing opportunity. The property is offered in compliance with federal, state, and local anti-discrimination laws. The attorney fees in any action or proceeding or arbitration between seller and broker arising out of this agreement, seller and broker are each responsible for paying their own attorney's fees and costs, except as otherwise specified in paragraph 22A. Additional terms here. This is the REO advisory, short sale information advisory, trust advisory. Seller intends to include a contingency to purchase a replacement property as part of any resulting transaction, right? So that would be the seller's purchase of replacement property, the SPRP form. If the sale of this home is contingent on them purchasing another home. And here under 19 is where I'd put the little caveat that the seller is responsible for paying for those inspections listed in section 10E, that I would put that, you know, agent will cover the cost of inspections on RLA, listed in RLA 10E. Unless property does not sell for any reason, then seller will reimburse agent for the cost of inspections, right? So something like that, that's where I put this, is under additional terms. Management approval. If an associate licensee in broker's office, salesperson, or broker associate enters into this agreement on broker's behalf and broker or manager does not approve of its terms, the broker or manager has the right to cancel this agreement in writing within 5 days after its execution. So we can sign this. We may agree to something crazy, insane, and our broker may be like, sorry, you can't take that listing and cancel it. The broker has the right to do that. Successors and assigns. This agreement shall be binding upon the seller and seller's successors and assigns. Dispute resolution is section 22. Mediation. Seller and broker agree to mediate any dispute or claim arising between them under this agreement. Before resorting to an arbitration or court action, mediation fees, if any, shall be divided equally among the parties involved. If for any dispute or claim to which this paragraph applies, any party, the non-mediating party, commences an action without first attempting to resolve the matter through mediation, or before commencement of an action refuses to mediate after the request has been made, then the non-mediating party is the losing party. And then if the non-mediating party is the losing party in any such action, the prevailing party shall in such action, let's try this again. The prevailing party in such action shall be entitled to recover attorney fees from the non-mediating parties, notwithstanding the terms in paragraph 18, right? So if somebody tries to step around this mediation, then instead of splitting all the costs associated with it, the prevailing party is entitled to recover those attorney fees from the non-mediating party. Exclusion from this mediation agreement are specified in paragraph 2B. Additional mediation terms. The following matters shall be excluded from mediation: a judicial or non-judicial foreclosure or other action or proceeding to enforce a deed of trust, mortgage, or installment land sales contract as defined in Civil Code 2985. So if we're in the middle of this listing agreement and the property gets foreclosed on, and so the sale is prevented, we don't collect any commissions, right? That doesn't fall under mediation. Unlawful detainer action, the filing or enforcement of a mechanics lien, meaning that somebody who did work on the property can file a mechanics lien against the property, and any matter that is within the jurisdiction of a probate, small claims, or bankruptcy court. The filing of a court action to enable the recording of a notice pending action for order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver or violation of the mediation provisions, right? Arbitration advisory: if the seller and broker desire to resolve disputes arising between them through arbitration rather than the court, they can document their agreement by attaching and signing an arbitration agreement, CAR Form 8RB. Entire agreements: all prior discussions, negotiations, and agreements between the party concerning the subject matter of this agreement are superseded by this agreement, which constitutes the entire contract and complete and exclusive expression of their agreement, and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. If any provision in this agreement is held to be ineffective or invalid, the remaining provisions will nonetheless be given full force and effect. This agreement and any supplement, addendum, or modification, including photocopy or fastmile, may be executed in counterparts. We can sign them. The seller can sign one copy. I can sign another copy. Totally okay, as long as the copies are exactly the same. Ownership, title, and authority. Seller warrants that the seller is the owner of the property. No other persons or entities have title to the property, and seller has the authority to both execute this agreement and sell the property. Exceptions to the ownership, title, and authority are as follows. You'd fill in that line. Legally authorized signer. Whenever the signature or initials of the legally authorized signer identified in the signature block below appear on this agreement or any related documents, it shall be deemed to be in representation capacity for the entity described and not in an individual capacity unless otherwise indicated. The legally authorized signer represents that the entity for which that person is acting already exists and is in good standing to do business in California, and shall deliver to broker within 3 days after the execution of this agreement evidence of authority to act in that capacity, such as, but not limited to, the applicable portion of the trust or certification of trust, letters, testamentary, court orders, power of attorney, corporate resolution, or other formation documents of the business entity. By signing below, the seller acknowledges that the seller read, understand, and received a copy of this and agrees to the terms of this agreement. Here is where the sellers would sign down here on the block. If it's an entity seller, right, we would check this box. So if this paragraph is completed, a representative capacity signature disclosure form is not required for the legally authorized signers designated below. One or more sellers is a trust, corporation, LLC, probate, estate, partnership, or other entity holds a power of attorney. This agreement is being signed by a legally authorized signer in a representative capacity and not for him or herself as an individual. See paragraph 25 for additional terms. The name of the legally authorized signers are, here's where you would put who's going to sign. If a trust, identify the seller as the trustees of the trust by simplified name, such as John Doe co-trustee, Jane Doe co-trustee, or the Doe Revocable Family Trust. If the entity is a trust or under probate, the following is the full name of the trust or probate case. So if it's an LLC, the buyer or seller's name gets listed as the LLC. If it's a attorney in fact type situation, or somebody has a power of attorney, we would list the original seller's names in the seller's lines. If it's a trust, the seller can be simplified by putting, instead of having to put the John and Jane Doe Family Trust, we can just put the sellers as John Doe co-trustee and Jane Doe co-trustee, whoever the trustees are of that trust. We don't have to put the seller's name as the actual trust. Okay, that's the only time where we don't do that. We no longer have to include the RCSD because we have this section here filled out. And then we would sign here, signature by the printed name of seller would go here, printed name of legally authorized seller. So if we check this box here, notice this box gets checked down here. So here you would put the name of the seller, which would be like the Buy My House LLC. That would be the legally authorized seller. And then here is where you would put the printed name of so the seller, whoever's authorized to sign on behalf of the LLC would sign up here. And then they would type their name in here. And if applicable, like on an LLC, they would also put in president, right? What their role is with the company. Okay, so that's how that works there. If you have more than 2 sellers, you would include this additional signature addendum, the ASA form. So only 2 people sign a purchase or a listing agreement. Seller 3, 4, 5, they sign an ASA form, and you need one every time you sign documents. And then you put in the broker information here. Dun, da, da, da. If you are co-listing the property with another company, you would check this box here. 2 brokers with different companies are co-listing the property. Co-listing broker information is on the attached additional broker acknowledgement. You need to add form ABA. Okay. Any questions about the 5-page listing agreement?
I have one, but I don't know if it applies to this. So I
Ask
have
away.
that vacant land listed
Uh-huh.
for sale. It's
Yes.
2 individual guys.
Uh-huh.
I was talking to one the other day, and he was saying that he's going to take his girlfriend by there, and if she likes the property, then he's probably going to buy the partner out.
Okay.
So at that point, we would just void the contract, or I'm not entitled to anything except for what I paid to put the sign up.
At that point, you would still be technically due a commission. That would be a prevention of the sale by the seller. So you would technically be due a commission for that. And
Okay.
in that case, if
Because I
you
would
have
have to
one
do the
seller,
paperwork to take the one seller off and just put it in the other, right?
yeah, you wouldn't even necessarily have to do the paperwork. So you can decide how you want to handle that situation. You can be like, great, I'd like to be, reimbursed as previously discussed for the cost of the whatever, because you're pulling it off the market. Technically, I'm because you're preventing the sale, I would be due the full commission, but because I'm a nice human, like just cover the cost that I'm out so far, and then I'll let you, pull it off the market and do what you want with it.
Okay.
Because to buy a partner out of a property, especially if it's a cash deal, there's not really anything you even have to do for that.
Got
They
it.
would
Thank
just,
you.
yeah, we can talk about that more off too. In addition, just so everyone knows, in addition to the residential listing agreement and those like 7 forms that were above the listing agreement, there's also a couple below. The seller's advisory is one, which just talks about the seller's duties in their role in the transaction of selling the property when it comes to disclosures, right? Their statutory duties, general disclosure duties, death and other disclosures, condominiums and other common interest subdivisions, contractual terms, legal requirements, withholding taxes, prohibition against discrimination, government required repairs, replacements, alterations, the EPA lead-based paint renovation, marketing considerations, pre-sale inspections and considerations, post-sale safety precautions. So I do recommend you read through that. It's an important one that outlines. Here's where it talks about, right? Many people are not aware of their defects or problems with their own property. One way to make yourself aware is to obtain professional inspections prior to sale. Pre-sale inspections may include a general property inspection, an inspection for wood destroying pests and organisms, and an inspection of the septic or well system, if any, among others, right? So there's where it talks about, hey, it's to help you in your disclosure to have those reports done. There's also the California Consumer Privacy Act disclosure and notice, just talking about the CCPA and the fact that there's lots of things in the real estate transaction that just become public record. We don't fall underneath this. And then it added some additional forms, but those are the forms that are included. You can't take those forms away from the listing agreement. Please have them signed with the listing agreements. And one day we'll make it through some of these other forms as well, because they're all important forms, as well as when you go through transactions, your mentor will help you with those additional forms as necessary. Any further questions before we wrap up for the day? Sorry for going over.
That's okay. Is Abby gonna put the sign in?
The attendance link? I'm sure she will.
Okay.
There you go.
Thank you,
Magic.
Abby.
So make sure you log your attendance, and we will not be back tomorrow, but I'll see you on Thursday at 4 o'clock covering the I don't remember what the beginning of it is, but it's basically contract to close and creating customers for life.
Closing the
Woohoo!
sale
Repeat
and
referral
creating
business.
clients for life.
Creating clients for life. That's what we're going to focus on.
Life. Okay.
Alrighty. Have a fabulous day. Holler at me if you need anything.
You know I will.